Get ready for the dictation. Start. There has been an intense and persistent crisis in the fairness of administering the death penalty in India for many decades now that has been acknowledged in judgments of the Supreme Court of India by former judges, lawyers, researchers, etc. At the heart of that crisis has been the concern that there is a pervasive arbitrariness in sentencing procedures that impose the death penalty, and a significant concern has been that barely any relevant information about the accused enters the courtroom during the sentencing phase. The court's recent judgment in Manoj and others versus State of MP seeks to address this long ignored yet critical aspect of death penalty sentencing. This specific attempt in Manoj must be seen with the court's apparent discomfort over the last year with procedural unfairness in sentencing being carried out by the lower courts. The constitutionality of the death penalty was upheld in 1980 in Bachchan Singh versus State of Punjab, which greatly emphasized individualized sentencing and called upon courts to consider the crime and the circumstances of the accused. However, since Bachchan Singh, there have been disagreements on which cases warrant the imposition of the death penalty and the nature of information about the accused relevant for sentencing. With a vast majority of prisoners being poor, quality legal representation has always been a concern. As a result, very little attempt is made to collect sentencing information, and very little is known about the accused while sentencing. Since September 2021, during Justice N.V. Ramanna's tenure as the Chief Justice of India, 3 benches of the Supreme Court heard arguments in 13 death penalty appeals and delivered judgments in 10 of these cases, resulting in 3 acquittals in one case and commutations in the rest. A common thread running across these decisions is a deep and acute concern surrounding the procedural fairness on the imposition of the death penalty and the lack of adequate information about the accused. The bench headed by Justice U. Lalit and also comprising Justices Ravindra Bhatt, Bela Trivedi and P.S. Narasimha has been particularly concerned over the lack of information about the accused. Recognizing the centrality of such information for a fair sentencing process, the bench passed an order in Manoj in September 2021 calling for reports of the probation officers, prison officers, and mental health professionals. In the final judgment delivered recently, the Supreme Court took important steps towards realizing an individualized sentencing inquiry as envisaged by the court in Bachchan Singh 42 years ago. Sentencing happens after an accused has been found guilty of the crime. Here, the circumstances of the accused are considered. This requires a broad-based inquiry, as scientific theories no longer see the accused as individuals who, out of their free will make bad choices unhindered by their past or present circumstances. Contemporary understanding of criminogenic factors among scholars and researchers focuses on analyzing past social histories, behaviors, and life circumstances of the accused, as human behavior is a product of a complex interplay of personal and environmental factors. There have been important efforts by courts to bring forth such information. However, the judgment of the Supreme Court in Manoj is significant for two reasons. First, it indicates a shift towards an evidence based inquiry in sentencing that invites expert opinions and reports from a wide range of disciplines. Second, it expands the scope of mitigating factors by calling for reports that bring forth pre-offense details such as socio-economic status, education, family background, and also post-offense details such as the conduct of the prisoner in prison. Mitigating factors pertain to life circumstances of an individual that can help determine punishment. Crucial to understanding the relevance of mitigating factors is connecting it to a framework that allows for contextualizing it to the individual's life choices and moral culpability, which is the essence of a just sentence stop.